2026. This is a council meeting dealing with a development charges complaint hearing. We have made the call to order. Does any member of council have a declaration of pecuniary interest at this time? Not being the case, the Development Charges Act hearing. 3A, we have a complaint letter. 3B, we have the development charges for 280 Jameson Drive, LPG PL 26-04. We have that report, and we have the information provided by the complaint. The Council of the City of Peterborough is sitting as an adjudicative body for a complaint brought forward to Section 20 of the Development Charges Act by the owner of property in the city. The complainant is 1439121 Ontario Limited, and the complaint is relation to a property with a municipal address of 280 Jameson Drive and the development charges other than those imposed under the Education Act. I understand that the complaint will be represented by the complainant hearing by their legal representative, Mr. Roloff and Ms. McConkey. Good evening, Mr. Roloff and Ms. McConkey. We'll deal with some procedural issues in a moment, but our intention is to provide the complaint with an opportunity to provide its evidence for the authors of IPGPL 26-024 report to provide their evidence and reply to any additions to the report we already have, if any. Such a reply limited to issues raised by the complainant and not otherwise addressed in the report, and to afford Mr. Roloff and Ms. McConkey an opportunity to make closing submissions. We will not be requiring witnesses to take an oath or affirmation, and we understand that the authors of IPGPL 26-24 are all present. We will not be affording city staff an opportunity to make closing submissions. Since council is sitting as an administrative tribunal with circumscribed powers under the Section 20(6) of the Development Charges Act, we expect that evidence and submissions will be directed towards the statutory power, which council will exercise under Section 20(6) of the DCA. In other words, we expect the evidence and submissions to be directed towards whether or not incorrect determinations or errors relating to the development charges were made. Once the evidence of the complaint has been provided, and any other evidence provided and submissions made by Mr. Roloff, Ms. McConkey, council will make its decision. I will endeavor not to interrupt the presenter of evidence, Mr. Roloff, Ms. McConkey, and city staff, but we do expect a quorum, and I will limit any repetitive or irrelevant evidence. Once Mr. Roloff, Ms. McConkey have been given the opportunity to make final submissions. Before we get started, I want to confirm that Mr. Roloff and Ms. McConkey that this matter will be in a public hearing. I do not see anything in the materials provided requesting that the hearing proceed otherwise, but did wish to confirm that if 1439121 Ontario Limit is requesting that matter proceed not in view of the public, will require something by the way of an explanation, then council acting as their tribunal can assess that request, and we may need to seek legal advice on that issue given the presumption of a public hearing under Section 20 of the complaint under the DCA. So allow Mr. Council to come forward.
Councillor Leal, we're not seeking that this be a closed hearing. We're fine with it being a public hearing. So just to clarify, just to make sure I understood the process correctly, Council, we're not to make general submissions. Essentially, we're going to take the complaint letter as it is. The additional material provided today, we can comment on that, and then we'll be allowed closing submissions. As am I understanding the
my view of reviewing on the material that everything needs to be directed towards Section 20 of the Development Charges Act.
Yes, so we wanted to expound further on the materials that we put before council already, and also to discuss further the implications on the business, which we had addressed in the complaint letter, to give further context to council.
Well, we want to make sure everything stays within that narrow scope, sir,
of
as
course,
best we can.
Okay. All right, so just give me a moment here because I'm going to take a narrower approach to this in light of the process that council has just stated. All right, so that being the case, let's deal with the additional materials that we submitted today. Apologies to council, obviously, for the late filing of those materials, or the 11th hour filing of those materials. The first thing I want to bring to your attention, which we didn't reference in the initial complaint, was the development charges background study. And this gives some grounding to the purpose that was intended for these development charges, and should have informed the process as to whether or not the exemption should have been lifted or not. So the development charges background study that was issued in 2024 by Hempson, which was given to this body and informed this body's decision as to the exemption amongst many other amendments that were made with respect to the development charges, indicated that the development charges should be applied with a view of fostering the growth of existing businesses, mid-size and small-size local level businesses. And part of what they emphasized in that development charges background study, amongst other things, was that to the extent possible, the development charges regime as it was should be maintained. The development charges study, also in section G of the executive summary, indicated and emphasized that the development charges should be levied with respect to new industrial lands. And this is a point I think bears a lot of emphasis here, because we are not dealing with new industrial lands. We are dealing with an existing industrial park, the Cleantech Energy Industrial Park, which was an established industrial park prior to the lifting of this exemption. And the exemptions themselves under section D of the bylaw, which is before council, all provided exemptions for existing industrial lands. What we want to impress upon council, and the development charge study makes it clear, is that the emphasis is on new lands, and this makes perfect sense. New entrants to the market should be paying some form of development charges for the new city services that are being made, developed, constructed in those new industrial parks. This is not intended to be applied in such a way that existing industrial parks where the services have already been in place for many years are now being levied with development charges to fund the development of some other brand new industrial facilities. So we did want to point that out. That was a new set of materials that was put before council today. It does bear emphasis that, in our view, the manner in which these development charges were applied, namely the lifting of the exemption, is unfair, because the development charges study itself gave the recipients of those prior exemptions a reasonable expectation that those exemptions would be maintained. And in fact, the development charges study that was put before council encouraged that. It proffered that view as what should be maintained as the status quo. And frankly, it's the logical approach. If a set of lands have already received the benefit of the site services many, many years ago, as is the case for 280 Jameson Drive, there should not be a lifting of the exemption to fund the development of some other unrelated, unattached industrial lands. Now, this is further emphasized by the fact that within literally a 5-minute walk of 280 Jameson, there's the Fisher Drive property. I Google mapped it. I made a point of doing it because I think it's a poignant and salient fact here. Literally a short walk away, industrial lands which were covered by the exemptions. Sorry about that. I don't know what that was. Which were covered by the Schedule D exemptions. That exemption has been maintained. We don't know why. The fact that there's a application of this lifting of the exemption in a non-uniform way in the exact same industrial park within a 5-minute walk, in our view, respectfully, seems unfair. And the court cases that we provided to council emphasize that there must be some degree of fairness in the application of development charge bylaws. They cannot be arbitrary, they cannot be capricious. There has to be some degree of proportionality and reasonableness to them. This case law is all before council. It was in our complaint. I don't want to expound on it too much, but I think the point you want to drive home is, absent any reasons, and there are none in the public record, we would submit that it's inherently unfair that two project sites, which are side by side, one gets its exemption taken away from it halfway through its development and is left with a project that will be killed by this bylaw. I want to make that abundantly clear. I believe it was clear in our initial complaint letter. 5 minutes down the road, somebody could be developing those lands and be completely untouched and unfazed by the lifting of this exemption. That contrast, in our view, on its face, is patently unfair. So very brief submissions there, just on some additional materials. My colleague, Ms. McConkey, will speak to some notice concerns that our client has.
Welcome, Ms. McConkey.
Thank you, Council. So just picking up where Mr. Ratliff left off, our client has some concerns. As Mr. Ratliff was alluding to, courts have recognized that a city has, quote, a responsibility to clearly communicate the development charge process to the developer. And we submit that the city did not fulfill this responsibility in this case. In the city's own submissions, which it provided in response to our client's initial complaint, it provided that, quote, on March 6, 2025, a prospective tenant for the property, 280 Jameson, participated in a pre-consultation meeting with city staff to discuss the site plan application requirements for the second phase. Although development charges were not explicitly discussed in this meeting, the formal record of pre-consultation letter issued to the applicant noted that development charges are collected at the time of building permit issuance, end quote. Notably, this pre-consultation letter merely provided the following. It stated, quote, the city of Peterborough collects development charges at the building permit stage. And it says for more information, you can seek more information at a website it provided a link to. The city did not discharge its duty to ensure that the development charge process was clearly communicated to our client in this case. Our client was under the impression that the project was exempt from development charges. And not only was it under the impression that it was exempt, but it was unclear from the outset of the pre-consultation meetings with respect to the second building that the development charges were going to be incurred. So just to reiterate, our client, though the city claims it brought up the issue of development charges, it did not do so in the specificity that is required to ensure that builders and developers are given adequate notice of the possibility that they will incur additional development charges partway through a project, which we consider to be a highly problematic issue.
So we can summarize what we had as far lengthier submissions and closing submissions. I think we could kind of get through that fairly quickly, but we're at council's disposal. So if you'd like, I can simply go through some broader closing submissions. Thank you.
If you go to your closing, please. I didn't have my microphone on.
Thank you, Councillor. All right, so in closing, I think what we want to do is just impress the practical reality of the situation here. Our complaint outlines the technicalities of why we feel the development charges have not been levied. We've given you some additional technical arguments for consideration. But the reality is here we're dealing with a business, and this business is Bravo Awards. And Bravo Awards has been operating in this community for 23 years. It started as a one-man operation and it grew to an operation of 22 employees that are now gainfully employed there. And this project represents the expansion of that business and the growth of jobs, the growth of tax revenue, and the growth of the reputation of this community, frankly, in terms of its viability and attractiveness for new industrial and commercial projects. The reality is here that Mr. McKillargy, who's the principal of this company, this is the culmination of their business efforts over their 23 years of being a meaningful, gainful employer, contributor to the tax base, provider of good economic opportunities for members of this community. The culmination of their 23 years of work is at stake here. If these development charges are levied, this project will not go forward. And as a result, the development charges, at least from Bravo Awards, will be $0 because it won't be developed. I think when we consider that reality, we need to think about also broader considerations. And I want to point out that it's not simply Bravo Awards and what it could or could not contribute to this community that's at stake. There are also many people who are ancillary beneficiaries of this. Kloosterman Contracting, who's been in business here for 35 years, and the PDCA's, Peterborough District Construction Association's open letter to council has been provided in our materials as well. And Kloosterman Contracting is a member of that, is the constructor on this project. And if this project is not going to go forward and is effectively killed by these bylaws, it's not just the impact on Bravo Awards, which we say is already bad enough. We want to impress upon council that the trickle-down effect of this does not stop with Bravo Awards. There will be a contractor who is out of job here. There will be trades who are out jobs here. This bears repeating, as opposed to if we work cooperatively, using the words of the development charges background study, and we work together to facilitate economic growth and expansion, and we ask council to work with our client cooperatively here in considering the fairness and the request to have the exemption maintained, the council will benefit, the city will benefit by having this project continue. Kloosterman Contracting will maintain its contract. Bravo Awards can expand its business and its operations. The city and the council benefit from the industrial tax rate, which is a higher tax rate, which our client will continue to pay, as opposed to if it doesn't go ahead, we lose all of that. And on top of that, Bravo Awards, and Mr. McKillargy informed me of this this morning, and I think it's a salient fact, which wasn't known to us at the time we filed our complaint, has already invested $287,000 in the development of the warehousing portion of the lot. So we're not just talking about Bravo Awards' ability to use and continue developing those lands. We're talking about $287,000 out of Bravo Awards' pocket that will be gone. It will have zero use, gone forever. No way to see compensation for that. No way to recover that. Gone. The other last point I want to make is what the city's future use of this lot will be if Bravo Awards development doesn't proceed. This is a big question mark, one that I think is worth considering. We now have a lot that has been half developed, and in the course of the development of that lot, a mutual driveway has been installed in contemplation of the warehouse that's going to go in. A stormwater management system and wastewater management system has gone in, which contemplates the first building and the second warehousing building that will not be constructed if the development charges are levied. And you're going to essentially have hampered lands. A developer is going to look at those lands. They're going to see a restricted use of those lands. They're going to see something that's partially developed. And in our view, it's something that's not going to be attractive to another prospective developer, essentially picking up the goods as they were left by Bravo Awards in their wake. So thank you, council. You've been very generous with your time and your consideration. We're open to your questions. We're at your disposal. And with sincere thanks from ourselves, but also Mr. McKillargy, who couldn't be here. He's attending to an ailing friend who's unfortunately on his last legs. He sends his thanks as well. So thank you very much.
Mr. Roloff, Ms. McConkey, will you be calling any witnesses this evening?
No, Mr. Legal.
Thank you very much. We do appreciate, Mr. Roloff, Ms. McConkey, your submissions this evening. We essentially have two courses of action this evening. We could make a decision on the complaint this evening, or we can, that decision respecting the complaint involving Section 20 of the Development Charges Act be reserved, and a decision and reasons would follow. Councillor Burke.
Mayor Leal, through you to the speaker. So you mentioned the word a few times, collaboration, cooperation. Are you aware of, because this project has come before council 2 or 3 times, are you aware of any collaborative efforts that this council has made on behalf of the proponent?
None.
Okay, thank you.
Anything further? We'll need some direction. Councillor Duguay, please.
Thank you, Mayor Leal. I would be prepared to move that we reserve with a decision to follow pursuant to your concluding remarks. And I trust I have the language correct. Thank you.
Seconder for that. Thank you, Councillor Baldwin. Mr. Kennedy, could you just repeat the motion that's been put forward by Councillor Duguay and second by Councillor Baldwin, please?
Thank you, Your Worship. It's been moved by Councillor Duguay, seconded by Councillor Baldwin, that a decision respecting the complaint involving Section 20 of the Development Charges Act be reserved, and that a decision and reasons follow.
Members, you've heard the motion. Maybe we'll go to a vote.
Thanks, Your Worship. My colleague's just going to load that for the purposes of a vote. Councillor Riel's a yes. Councillor Baldwin's yes.
And that is carried.
Thank you.
The next item of business, the confirming bylaw 26039. Someone like to move that? Councillor Vassiliadis, Councillor Crowley will go to a vote.
Councillor Baldwin's a yes. Councillor Riel is a yes.
That's carried. Motion to adjourn. Councillor Beamer, Councillor Hickey will go to a vote.
We're adjourned.
We'll come back for a general committee meeting. 5:50.